Good morning, Honourable Chairperson and Honourable Committee members, some of whom I've had the pleasure of meeting and some of whom I still have to meet. I am Daniela Ellerbeck, an attorney and the Constitutional Programs Manager at the FW de Klerk Foundation. The Foundation is dedicated to upholding the Constitution and making our constitutional democracy a reality for all South Africans. The Foundation commends this committee for a bill that has as its intention to align South Africa's intelligence services to the high-level panel's recommendations to split foreign and domestic intelligence services. However, the Foundation is concerned that the bill directly infringes upon various constitutional rights, for example, privacy and access to justice. The state is not only bound by these rights, but is in fact constitutionally obligated to uphold, protect and promote them. Now, the bill's broad surveillance scope risks eroding privacy, empowering state interference, stifling dissent, and endangering democratic principles, raising concerns for abuse. Now, the net effect of the bill will be that it will empower the South African Intelligence Agency, tasked by the bill with domestic intelligence, to conduct security competency tests on, quote-unquote, person or institution of national security interests. Now, these tests are for the purposes of issuing a security clearance certificate. The implied risk is that should you fail to obtain a security clearance certificate, you will no longer be able to continue operating and possibly even face criminal prosecution. Now, the bill contains various problematic definitions, which the Foundation will fully canvass in our written submission to be submitted later this week. The most important to note are that, first, threat is undefined. Now, threat is a crucial concept underpinning the entire bill, as well as various other definitions. The second is that a person or institution of national security interest itself depends on two concepts, both of which are problematic. The first is that a person whose activities are seen as being inconsistent with Section 198 will be seen as a person of interest. The problem is that any action that is seen as affecting South Africa's resolve to live as equals, live in peace and harmony, and be free from fear and want and to seek a better life is contrary to Section 198. So you have this very wide section, and the unintended consequences of such an overbroad definition is that potentially everyone could be seen as a person or institution of interest. Now, third, national security and opportunity or potential opportunity are highly problematic because the definitions are circular. This will be properly explained in our written submission. But this renders various other definitions in the bill unworkable. 4. The definition of security competency test contains a disjunctive reading. In other words, the use of an or as opposed to an and of the factors, making it overboard because literally every citizen in the Republic can be deemed to be vulnerable to, example, quote-unquote, manipulation. But this does not mean that they are a threat to national security and that the state should be able to administer a security competency test on them. Adding to these problematic definitions, the bill makes it compulsory for the agency to conduct vetting investigations to determine security competency, again for the purpose of issuing this security clearance certificate of persons or institutions suspected of being threats or potential threats to national security. Now, given the bill's problematic wide definitions, these clauses will allow for civil society organizations and those working for them, such as the Foundation, to be seen by the agency as persons or institutions of national security interest and to subject them to a vetting investigation to determine their security competency. In other words, should they be granted a security clearance certificate or not? Now, if you should not be granted a security clearance certificate, the implied risk is that you would have to close your doors and you might even face criminal prosecution. All of the above makes the bill open to abuse by future governments wishing to threaten or even silence voices critical or opposed to it. In light of this, the Foundation proposes the following remedies. Again, these will be fully canvassed in our written submission submitted to the committee later this week. The first is, let's define what a threat is. The Foundation submits that this should be defined as impending danger of serious harm to the Republic as one sovereign democratic state founded on the values set out in Section 1 of our Constitution. The reading should be replaced by conjunctive reading, so that the definition reads that this is administering a vetting investigation to determine the security competence of a person in order to determine whether such a person is suitable to classify information or critical infrastructure of the state. Such vetting investigation should consider whether the person is a security compromise because they are seen as vulnerable to blackmail, undue influence, or manipulation. Thank you for the time.